Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 61 in the list of AOR leading cases, and the case is titled as Dheeraj Mor versus Honorable High Court of Delhi. Now, this litigation is arising out of various other writ petitions that has been filed before the Supreme Court of India, and it has been decided by a three judges bench, by a division bench. Okay, so Justice Arun Mishra and Justice Ravindra Bhatt is presiding the bench, and they are deciding. Now, the moot question. Okay, so the main question that is in consideration before the bench is that can a sitting judge, okay, so can a judicial officer, sitting judicial officer, apply for a promotion to district level cadre through a route which is meant for advocates? Okay, so this question is the moot question which is arising before the Supreme Court of India in the case of Dheeraj Mor versus High Court of Delhi. Now, the brief facts goes like that: the petitioner applies for the post of district judge through direct recruitment, which is a route reserved for practicing advocates with at least 7 years of experience. Now, his application, of course, when he applied for the post directly, it was rejected because he wasn't a practicing advocate, but rather he was a judicial officer. Now, what is the relevant article in the consideration that has to be taken is Article 233 of the Indian Constitution, that is herein that is in the question herein. Okay, so Article 233 of the Indian Constitution. I'm using the Indian Qanun's website. So Article 233 in the Indian Constitution provides appointment of district judges. It speaks appointment of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state, in consultation with the High Court exercising jurisdiction in relation to such state. So for a district judge to be appointed in Delhi, governor and High Court in consultation will be deciding the matter, or in any other state concerned. Okay, now clause 2 is in picture here. Clause 2 is saying that a person not already in the service of union or of the state shall only be eligible to be appointed as a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by High Court for appointment. Okay, so now the conditions that are imposed in clause 2 is that he must not be already in the service of the union or the state, and he shall also be eligible if he has completed the 7 years of experience as an advocate or a leader. Now, what is happening in this case? Okay, so we will have a look at this case. Now, what is happening herein is that someone who was advocate for 7 years, okay, so the person has completed his practice for 7 years, can now he come to district judge cadre and he is appointed as a judicial officer. Now, can he invoke this route for a advocate to claim the position or to apply for the position of a district judge? Okay, now Supreme Court, it's a 3-judge bench. Okay, now the Supreme Court is taking a very firm stand in this case. The judgment is delivered by Justice Arun Mishra, and he is holding that judicial officers are not, okay, so the judicial officers who are already working, who are already serving in the state, they are not eligible to claim the 7 years practice experience. Even if they have practiced before coming in the judicial services, they are not eligible to go by the way of Article 233 for direct appointment in the district judges. Okay, now because there is a quota reserved, so some percent of quota is reserved for the people coming for direct recruitment with having 7 years or more of the experience in litigation or advocacy, and there is another fixed number of seats, fixed number of percentage that has been allocated for within the service promotion. Okay, so now the court herein is saying that when we are deriving this mechanism, we are not making it as a competitive mechanism, but rather we are creating two parallel channels, one by which judicial officers who are already in service, they can come and they can seek promotion inside by within inside promotions, right? And the external advocates who are practicing and are having 7 years or more of the experience, they can also come and join the judicial services. Now the court is basically emphasizing that it is the intent of the legislature, it is the intent of the constitution, that two separate streams shall be maintained, one for those who are already in the judicial services and one for the advocates coming from outside, because this is important to ensure that there is diversity, there is academic diversity, or there is, advocacy, brilliance in advocacy coming into the bench from the bar also. And so integrity of the judiciary, the integrity of the institution of the judiciary shall also be maintained, right? Now there is another argument that is coming in this case, which is that if you are not allowing us to sit in the exam, if you're not counting my experience just because I am reinstated in the judicial service, or I am instated in the judicial services and I have a 7 years of practice, then that is violative of my article 14 and my article 16 as well, which is, giving me the right to equality and right to equal opportunity. But then court is saying, court is invoking article 14 here, court is invoking the doctrine of reasonable classification here, that the distinction that has been made has an intelligible differentia which is promoting the integrity in the bar, which is promoting the diversity, the intellectual diversity in the bar, and hence it is a reasonable classification which cannot be just said to be ultra vires or a violative of article 14 or article 16 in the constitution of India. Now the key takeaway from this judgment is that if you are a person with 7 years of advocacy experience and then you become a judicial officer in lower judiciary or at senior civil judge level or junior civil judge level, that doesn't make you eligible to claim the 7 year services quota and get a direct entry in the district judge. Okay, so judicial officers who are already in service, they cannot apply for district judge through direct recruitment meant for advocates, because there is a clear bar. When we look at article 233, there is a clear bar. The first condition is that the person should not already be in the service with union or the state. Okay, so he should not be in the service with the union and the state already. Okay, if you are in the services with union or state, then if you are a judicial officer, then definitely you are serving the state or you are serving the union. And since you haven't practiced and you are sitting in judiciary itself, then what makes you eligible for coming into the exam by direct recruitment? So article 233 clause 2 is creating a very clear bar when you are serving in judicial capacity, when you are serving as a judicial officer for the government. And therefore there is a balance that this judgment is aiming to strike, that there is a balance between internal promotions, fresh entrants from the bar, people who are having 7 years of experience of litigation or more, or advocacy, or they are pleading before the court. They can also have advantage of coming to bench from the bar and help in reshaping the higher judiciary, the impartial judicial system, etc. Right? So I hope this case is clear to you. I hope the discussion is useful to you. The discussion majorly has revolved around Article 233, Clause 2, and it is holding that even if you have 7 years of experience before you are joining the bench as a judicial officer, or even if you are a judicial officer, that does not count as an experience to be eligible for the direct entry into the higher judiciary or district judiciary, because there are two various quotas by which the aspirants may come, one from the inside promotions within the judiciary promotion, and one another is the fresh recruits from the advocacy, right? So this was it, which was held in the case of Dheeraj Mor versus High Court of Delhi. I hope the discussion is useful. For more such videos, please stay tuned with us on Legal Darshan. Thank you for watching. Have a nice day.